Good morning, everyone, and welcome to our first event dedicated to the Finnish Whistleblower Protection Act. Welcome, a warm welcome from my side. I am Paola Simonetti, and I am in charge of leading the international marketing team at EQS Group. Together with me, we have our two guest speakers and partner, Antti and Timo, and our country manager for the Nordics, Ulrich. Welcome again, and thank you so much for being here. Antti is the co-head of KPMG Global Compliance Group and the director of legal services at KPMG Finland, whereas Timo is the head of forensic at KPMG Finland. So again, a warm welcome from my side. We are super happy to have you here. And also, of course, we are happy to have my colleague Ulrich with us, who is, as said, the country manager for the Nordics. Welcome again.
Good morning, everybody.
Good morning.
Mornings.
Good morning.
Great. So let's move on the agenda for today. Let's have a look at what we will be talking about before giving the word to our guest speakers to our guest speakers. So I will start with a brief introduction of EQS Group, who we are, what we do. Then we're going to talk about the whistleblower protection and management system and law and regulation in Finland. We're going to have a look on the practical side, and we're going to explore how a digital software solution can assist you at comply with the requirements, but also at having a system which helps you detecting risk and detecting the risk, basically. And then we will close the session with a presentation regarding how to management the report and the investigation phase, which is, of course, a very important and critical phase that follows when the cases arise into the system. Obviously, you have to be sure you manage them properly. So in the platform, you can see different buttons and different boxes. As you can see, there is a chat that allows you to ask questions to our speakers. Please do ask questions, share your feedback with us. We will try to answer all the questions at the end of the session. And if we cannot do it, because we just have 1 hour time, we will try to answer all the questions during the next days. So please share questions and thoughts in the chat. You can also download some documents. They are for free. They are our white paper. You can find a white paper on the status quo regarding the implementation of the EU Whistleblowing Directive in every European country, which has been written by several partners of ours in the different countries. Of course, the one regarding to Finland has been written by the partner you can see today, so by KPMG Finland. So have a look, download it for free. And in case you want to have a look also at what the other countries are doing. And of course, you can request a one-to-one meeting together with us in case you want to have a deeper understanding about processes, about our solutions, and about how we can support you at getting compliant very, very soon, because you know the commencement date of the law is in not even 1 month. It's going to be on the 1st of April. So jumping very quickly into who we are, EQS Group is an international software provider. We have our headquarters based in Munich, based in Germany. and we started our journey back in 2000, so it's almost 23 years now. We have more than 20 years of experience at developing software solutions for investor relations and for obviously the compliance solutions. We have more than 9,000 customers for every product that we offer, and regarding the whistleblowing solution that we have more than 2,500 clients. So of course, as you have seen Ulrich is our country manager for the Nordics, and he's based in Copenhagen in Denmark. We have several offices around Europe. You can see them on the red dots on the map. So moving forward, of course, there are several reasons why you should consider us or consider working with us, which are the flexibility we can offer, the expertise and the compliance due to the many years of experience that we bring. Of course, a global knowledge, thanks to our partner network and many initiatives for free that we are organizing on a local and on an international level. The one you'll be seeing today we are going to talk about whistleblowing, as you know, and we are going to have a brief look into our application for whistleblowing, which is EQS integrity line. This is just said an application that belongs to a much broader and complex platform for the compliance. This is an integrated compliance platform where you can from which you can not only manage the whistleblowing parts, but also other processes that you have and that are strictly related to the compliance daily business. The last slide is just some logos. Those are just, as said, a couple of ones or a couple of clients that we have and that choose to work with us. But yeah, we are really proud about our clients and about the long-term relationship we have established with them, which is why we are happy also to show a couple of names. So that's it from my side. I remind you, you can always send us questions, feedbacks, and thoughts in the chat. And now I am happy to give the word to Antti for his presentation regarding whistleblower protection and management in Finland. Antti, over to you. Thank you.
Thank you, Paula. Good morning on my part too. So Antti Aalto from KPMG. KPMG is a slightly older organization than the EQS. I think we are approaching a century as we stand. Globally, we employ about 240,000 experts and about 3,600 lawyers across the globe, basically. And in Finland, we are just about 2,000 experts, so a broad range of expertise, assistance, and guidance available. I will very briefly today go through the national law requirements, but I'll focus, having taken notice on the extremely high quality of the registrants today. I will assume that most of you have read both the directive and the national law as they now stand, and maybe draw your attention to sort of pertinent details that might be of assistance to you in implementing and considering on how to implement and improve your arrangement towards whistleblower compliance. So with that, please bear with me. One of the most important questions is how do we interpret the national whistleblower law? And the European Court of Justice and European Union basics basically state that the European Union law has a primacy over national law, and that's a principle that's been tested in the European Court of Justice. So what we have to appreciate is that if there's a national deviation from the directive, we should appreciate the directive with the principles basically stated in the Faccini-Dori case of I think almost 30 years back. So that's a word of guidance there in relation to interpretation of national law. What we have basically, and what most of you have actually read or seen before, is basically the six requirements for a whistleblowing system and arrangement to be compliant and to provide the benefits it can provide to an employing company or group. Basically, these are stated pretty much in a similar manner in the national law as in the directive. So the directive and law by themselves enable for the channel to be limited to certain areas of law. And on the other hand, the appropriate management of employer might require otherwise, and that's an issue I will touch upon at the end of my stint here. But let's just run through the six sort of pertinent items that we need to have in place. So first of all, what EQS is providing to the pot as a very important component is a reliable and credible system. And with that, we need to be aware of GDPR requirements and whistleblower legislation requirements, also employment law requirements and company law requirements. So not all systems on offer are capable of being configured to be compliant with the legislation. National law reporting methods, basically, there was a bit of a spelling error in the proposal for the Finnish Whistleblower Act, and basically what the end result is that you should have a system capable of either receiving written or oral notifications, and thereafter, of course, if need be, you are liable to arrange for even a personal hearing should that be requested. The channeling rule is in the Finnish law is basically probably easier to understand than as based on the directive, but the channeling rule is very important in the sense that if you have a compliant system and process and you have communicated the compliance in a credible way also to your staff, you are in a position to require for all staff to primarily utilize the internal channel. And this, of course, gives you and the management the benefit of additional information, plus the benefit of that information not being leaked out of the organization. And we have very practical examples of that in the short history of whistleblowing in Finland as a sort of method of obtaining and curtailing the public discussion on matters that actually are within the domain of corporate management. Pressing on other requirements, so this is an employer liability, and the question is on the national law, should we interpret it as a group structure or a single company issue or a single employee issue? A bit of a broad question there. I'll just point out that the directive originally the original wording of the directive started from the expression of a center of the economic interests, so a competition law definition of that is broader than just a group of companies. So that might give you a hint on how things should be approached and how they can be approached in designing a group structure, as a system for a group structure. Resolution body for the whistleblower issues, the national law is fairly simplistic on that and assumes that there are sufficiently independent persons within the organizations who are capable of addressing all issues, which is slightly a childish approach in my opinion. Hence, most companies have a bit of a organization or a board deciding on whistleblowers that might target the management, even top management of the organization. Documentation retention, I think that's pretty clear. The national law sets out a retention period of up to 5 years, which is, again, interesting as such, whereas for example, companies law in Finland states that, okay, if the matter is sufficiently grave, the liability time bar of a limited liability company management closes in 1 + 5 years. So that gives another way of approaching what you need or should actually retain from the documentation. Transparency training communication. Okay, this is a interesting. The Finnish law actually does state that employer is liable to inform. I think that the directive as such requires education rather than informing the staff. Hence, you might want to consider the differences in wording in a directive and national law. Clear and easy access to all relevant users of the channel, to the channel rules and channel itself. Surprisingly, many quite well-educated organizations have struggled a bit with that and basically placed their link to the whistleblowing channel exclusively, or tried to suggest it place their link exclusively on the internet and not internet, and probably on a URL that is controlled by the employer entity. So that's probably not what the directive actually aims for. Labor legislation issues, then basically in Finland you are required to impose a change of working rules, or even if you so wish, working terms, and that is of course done through cooperation procedure, on top of which cooperation procedure is if you are applying or introducing the whistleblower system for the first time, is required for the sake of processing employee data. So one more thing to sort of get properly done and documented. GDPR, that's a song for itself, and even a dance if we go there, but I think it will suffice at this point to state that data privacy impact assessment and the data handling policies are of essence. So basically more things to do and take care of, and basically further consideration is how do you integrate that into your data management policies. As a general rule, as an employer, you are not required to deal with especially sensitive information as defined in GDPR on a regular basis at all. So this is probably the first time that you are required and entitled to deal with especially sensitive personal information in the midst of your corporate data processing activities. And this slide, I used to state that this is the slide I hate the most in our deck. This basically sets out in the balls the areas of European Union legislation that are required to be called in to this protected, reliable, trustworthy whistleblower system of an employer. But the small blue box at the bottom basically states that, okay, whilst you are required to call these balls into the web of your whistleblower system, what you actually want to do, and by requirement of Limited Liabilities Companies Act, Cooperatives Act, and Foundations Act in Finland, in order to cover the management liabilities and the reversed burden of proof of the management discharging its duty of care, you actually should call in all items, actions, and omissions that fall within the supervisory duties of the board and the managing director. So this is what you are required to achieve by law, basically. And this is a fairly fundamental requirement that usually or quite often in the hectic life of legal professionals and compliance professionals might get sort of backseated. And in some occasions we have been in the less than funny position that the audit committee or board of directors chair actually pulls back the implementation process and says that, okay, we in the top management are liable to have this process efficiently and effectively implemented and working. So this is how we are going to do it properly. And of course, they have the call to do that, but in the normal rush hour of daily work, that might get sideset at points. And then what you might find interesting is a bit of examples of real life issues in the implementation. And in an implementation process, I'll start from top left. Who are your stakeholders? Usually it's HR, internal audit, compliance, legal, might include someone from IT. And the likelihood of finding time from everyone's calendar on an appropriate spot to inform and educate them about the legislation and the requirements might be a bit of a hurdle, but usually that's effort well spent. And what does take place if you so communicate with the stakeholders? Yes, it is hopefully the case that everyone gets the approximately same understanding of what needs to get done, what needs to be achieved, and how that can be done. Moving on to right, top management, not in one occasion, but on several occasions, those charged with the daily management of the company, CEO or managing director, and his immediate or her immediate staff, might have had a bit of a sort of hesitative approach to whether or not they actually like the existence and good management of whistleblower system. And in most cases, the attitude rapidly transforms as the information and the understanding of what this system actually is capable of and how it can be utilized and how it cannot be misused or abused is understood properly. So that's a bit of a communication issue there. Bottom left, understanding of solution requirements. That seems to be an issue that is diminishing in importance. It seems that quite a few organizations have understood that okay, public cloud is probably not the place to host this type of a service, and there are other technical issues that might be less than satisfactory. The thing that keeps popping up is the process requirements.
And now you've been presented what the law says. What are the requirements of the directive and national legislation regarding this process? And you just saw what is the platform that can be used to handle these cases. As you might have guessed, we have a service that we have helped our clients, both public and private sector, to implement these channels and processes, and as well as managing these reports for our clients. So we have a practical experience on to both implementing and running this service. This is a very basic process start, how it works. And basically, I don't have time to go through it on a detailed level, but basically I'd like to highlight a couple of things only. Because of the conflict of interest is a key issue regarding the legislative requirements of this matter. Our clients have engaged us to handle the incoming reports for that reason, because that's one of our things that we assess when we get the report. We read the report, we do the notification required by the law, etc., etc. We assess the urgency, content, reporter, and other topics as well. But conflict of interest is a key issue as well. So basically, we channel the report to the right decision-making level of a client. If we identify that maybe the normal decision-making level is in conflict of interest situation with this particular report, we escalate to the next level, and we have done that in about 5% of the cases that we have got. But I'll move on to the next slide, which describes how our experiences on handling these reports. First, I go to the approach of most of our clients because that kind of gives a background of where we are coming from. Most of our clients, and typically in private sector, all our clients invite all type of wrongdoings to this channel. They don't have different channels for different things, only one channel for all type of wrongdoings. In public sector, they usually have several channels for different types of issues, and mostly public sector clients invite only the issues that are in the scope of the national law. And of course, as mentioned in the Antti section, active communication and training is required by the law. So basically, all our clients have done that, and therefore we assume that most of the employees of our clients are fully aware of the process and use it as needed. And also, anonymous reporting is allowed by the most of our clients. And again, the public sector is more inclined to go towards the reporting by name, but all our private sector clients allow anonymous reporting. As you see in the bottom part of the slide, that anonymous reporting is used by 77% of the reporters. So if you don't allow anonymous reporting, you might lose a lot of information. So I really recommend allowing anonymous reporting. We have learned that most of the reports that are reported through these channels are quite short and sometimes contain several different events, maybe different cases also. So basically, one report might lead to several investigations or different development topics. And it's interesting to also notice that what types of information or reports are reported through these channels. Most of them are HR type of issues, problems between employees and supervisors or employees themselves. Then, of course, there are economic type of issues, embezzlement, fraud, occupational health, misuse of alcohol, misuse of drugs. This type of issues have been reported through these channels. And only rarely those topics are covered by the whistleblowing legislation. That's our also one key remark in this topic. Quite often when we were discussing this directive a couple of years ago, when there was no national laws yet, but quite many of our clients were concerned that this channel will be used maliciously, that there will be wrong type of reports made, but we have not witnessed that at all. And as you see in the bottom part of the slide, that 82% of the reports will lead to investigations or other type of development actions. So basically only less than 20% of the reports, no actions are required. So that's kind of tells a strong story as well. What is a disappointing fact that when a reporter enters the report to the whistleblowing channel, they are quite lazy to follow it up. We are asked 23% of the cases more information from the reporter, and we only get 25% of the cases we get something back from the reporters. So basically, that is kind of a worrying part of it, and may require for more active communication and urging reporters to really be active on this topic. And only 26% of the reporters will return to the channel to learn what has been taking place for because of their report. So basically, those are key remarks that I want to raise, and as well as the 4% had a conflict of interest situation with the basic decision level is also something that you have to really take into account that when implementing your systems or processes. There's many things to be discussed, but we are running late, so I'm going to concentrate on a couple of issues. Maybe that this is something that you are mandated. You have a duty to investigate and act. It's not a voluntary thing that when you get the report, you must look into it, and if you find that report is accurate, you have to take an action. And that has to be documented and justified what kind of actions you are taking. And quite often, the documentation part and justification part of different type of actions are the kind of a weak area. So I really urge you to pay attention, of course, the action itself and how you document it and how you justify your actions, especially if you opt to take no action at all. You have to be very careful to justify it properly. Requirements for the case managers and investigators, you have to nominate them. They just, of course, you have to nominate the normal, regularly people that are regularly handling these cases and reports. But of course, there's an ad hoc need to nominate somebody for some specific type of investigation or case management. Then you have to ad hoc nominate them. And you have to keep record of that, because that is also a key issue. Who has the right to look into that particular report? Of course, case handlers and investigators have to be free from conflict of interest situations, and they have to be competent, knowledgeable. They have to know what they are doing. Of course, the confidentiality of the process is a key, because of the protection of the whistleblower is in the core of this legislation. And also, not only the whistleblower confidentiality is important, but also the target person's confidentiality has to be taken into account and kept secret throughout the process. Basically, I think I'll end here in my presentation, that there will be some time for the questions and answers.
Yes, great. Thank you so much, Timo. Thank you so much indeed. We have received different questions, and let's have a look at the question that you have received. So the first one was during Andy's presentation. So I'm going to read the question, which says, is it correct that if the formal channel exists, it is not allowed to use other channels?
I'll rephrase the question. So if there is a request by the company or employer to issue whistleblowers to the dedicated whistleblower channel, omission of that duty, if that duty is indeed factually in force as a term of employment contract, then it could be interpreted that it is only allowed to notify suspected wrongdoings through the whistleblower channel. However, I would probably not be as strict as to sack somebody on account of maybe telling the chief legal or chief compliance in person of suspected wrongdoing and not reporting directly to the channel, because that is one of the sort of great indications of a good integration and trust within the organization, that people can actually feel confident to come forward with their own face and own name, and be recognizable as pointing out a suspected wrongdoing or omission of duty. So I hope that covers that pretty much. But the issue is from the whistleblower side. So whoever is notifying is, of course, that if you use other than protected system and process, you do expose yourself to a risk of retaliative action, and it might be difficult to evoke your rights to protection as a whistleblower then. Good question.
That's a very good point. Of course. Thank you. Thank you for that. We have received 2 questions for you, Antti, related to a corporate group. So companies that have like a group of companies and that operate internationally. So the question are, what are the requirements for those kinds of corporate groups, and if they can have a centralized solution, because those the handling the whistleblowing cases in this kind of companies has been an issue in different law and legislation we can see throughout Europe. So if you could give us an insight on that, that would be perfect. Thank you.
Okay, that's the topic of a book. Basically, let's start with the Finnish law. The Finnish law actually seeks to be silent on whether or not group solutions and group processing is allowed. What I would say that the Finnish law authorization clause that's been very carefully coined to be very obscure. It is not legally possible to have per se a centralized system and a solution and process. On the other hand, it can be made to comply, but that is a bit of a combination of implementation process and a specific contractual arrangement within the group that needs to include and pay attention to the employee rights also. So that is a bit of a difficult question, and as the reference was to Denmark, at the request of Denmark, actually, European Commission in the summer of 2021 issued an opinion on how whistleblower legislation and directive can be interpreted, and the Commission interpretation was that no cross-border or group centralized solutions are not what are in the directive. However, I'd like to add, for the benefit of doubt, that the directive itself does not prohibit that. But this is a pretty broad question, and we've come across this, and we've done implementation over at least 17 countries within the European Union. So we have a process and the sort of contract template to make it legal and make it possible to centralize those systems.
Thanks. I don't know if you, Ulrich, also wanted to add something on that.
Yeah, but I think it's a very, very good question. And if I can see one of the other questions also, if we did any technical changes because of this EU directive to our platform, then the short answer is no. But what I then have seen is that our platform, the functionality is being used in a different way now, and this corporate corporate thing is one of the places because as Antti just said that here in Denmark, but then you're allowed to have corporate solutions, and then we have other countries that says that they don't allow it. So that is where suddenly we see that case routing is being used, so that some groups say, okay, we try to keep as much centralized as we can, but we also can see in the directive that we need to decentralize, and then they will use the functionalities to say, let's say we have a country that doesn't allow group, but then reports from that current country that is being sent directly to the other country decentralized. So the functionality in the system is being used in a different way due to this EU directive that we are talking about here.
We have even live cases in multinational companies or groups of companies that have already started to decentralize the processing and who are coming back to centralized process. As of course, if you have the processing facilities in several countries, that is likely to add complexity and cost to the running of the system. So you can go both ways, but whichever option you choose, it is advisable to think about the sort of life cycle cost and the process complexities. Hence, I would think that in most groups of companies, a centralized system is and processes is what is worth aiming at.
Great, thank you. We can also run another webinar on that because we keep receiving questions for a big group of companies. So this could be food for thought for another webinar. We also have a question for Timo, which is a really interesting one, in my opinion. And the question says, if you have noticed any differences between company types and reporting activities?
A good question. We have different company types among our clients, but I can't really find any clear characteristics that would describe this, would be a good answer for this question. So, the bigger the company, the more reports. That's of course natural statistical thing, but not really, nothing really kind of stands out from the different types of companies. That's
we will
maybe
also.
I think the biggest difference. I think the biggest difference is the internal communication. If you get this rollout in a good manner in your company, you will get more reports. So I think that's one of the big triggers in terms of number of reports coming in.
Yes, and we will also run a survey on our existing clients and prospects. We already had a couple of surveys run on a national level in order to provide you with information also regarding the number of cases that comes into the system, and also to analyze which kind of difference we have among different types of companies. But as soon as we will have the data, we will of course provide you with the data, because this is something which is helpful and is interesting. Also, when we think that at the end of the year, the smallest company will have to apply with the requirements of the directive and of the law, it can be also good information to them to have a look at what the bigger companies are doing and have been doing since now. So if you are okay with it, I will quick move to the final part of our presentation. Just a short reminder that we as a EQS group, we organize different kind of events, and as the one that you are attending this morning, we have 2 blog that you can find for free, of course, on our website. One entirely dedicated to whistleblowing topic, and the other one dedicated to compliance topics in general. And we also promote a white paper as the one you can download for free on the event platform, as I said at the beginning. Regarding the events, just a short heads up, we run an event next week on the 14th of March, and the event will be dedicated to the analysis of the link between organizational culture and whistleblowing and the whistleblowing system. So how can we foster the usage of a whistleblowing system throughout fostering a speak-up culture in your organization? If you want to register, all our events are for free and virtual, so you're more than welcome to join us next week. So now we have 5 minutes. Yeah, well, we are 5 minutes late, so I think we can be pretty much happy with the time that we spent together. We gave you a lot of different information. We will also be sharing the slides with you and also the recording of the webcast. So if you want, you can watch it at any time again. Of course, you can also schedule a meeting with us, with Ulrich for sure, but also together with Antti and together with Timo. We are here to support you and to give you full support, not only when it comes to implementing a solution, but also when it comes to writing your whistleblowing policies, managing the cases, and also the investigation parts, as we saw today. So I really would like to thank our speakers, our guests, my colleague Ulrich for being with us. And yeah, thank you again. It has been a pleasure for me.
Thank you, Paula. Thank you
very
Ulrich.
much, everyone.
Thank you.
Thank you, audience. Good questions, and from judging from the questions, rapt attention. So pleased to be here.
Indeed. And see you soon at our upcoming events. Have a nice day and enjoy the week ahead. Bye-bye.
Bye.
Bye-bye.
Bye, everyone.